Hello, good afternoon. Thank you everybody for coming. As most of you know, on October the 13th, the Supreme Court of Canada accepted Ontario and Alberta's position that the vast majority of the Federal Impact Assessment Act is unconstitutional. The Supreme Court made it clear the Act was needlessly redundant and infringed on provincial prerogatives, and we saw how it was slowing down projects. So, we're pleased that the court made this decision, but more needs to be done. It was just a reference, and we need a decision. Today, Ontario is taking immediate legal action to clarify that the Federal Impact Assessment Act does not stand in the way of our province's many critical infrastructure projects. We will be affirming the Act's unconstitutionality by applying for judicial review. And I'll tell you why we're pushing forward on this without delay. The federal government's response to the Supreme Court's opinion has created unnecessary confusion. Federal ministers have stated that even though the Act was ruled unconstitutional, they'll continue to enforce it and apply it to the provinces. And in the meantime, they claim, they're going to, quote, work on it. This is not acceptable. We all know that Ontario is growing at a remarkable speed, and we have a duty to ensure that our historic work building new infrastructure and services can move forward without delay. To support the needs of our growing population, we need highways to tackle gridlock and get people where they need to go. We need to build homes, and we need to ensure that Ontario's energy system remains world-class and reliable. And we're making great progress meeting the needs through a number of landmark infrastructure projects. The projects have been reviewed by Ontario's thorough, robust, and exacting environmental assessment processes, and is done in consultation with our key partners. We need the federal government to respect these processes and not stand in the way of critical projects. By getting certainty that these projects can proceed, we'll be able to continue our vital work building the strongest possible province. And it's what the people of Ontario need and expect and deserve. Thank you. Merci, Megwitch, and I'll take questions.
Minister, have officials in your ministry raised what to do with the responsibility of any prosecution coming from the Greenbelt matter to you or your office?
That's a matter you're going to have to discuss with the RCMP.
It's completely separate from the RCMP. I'm just asking if officials in the Ministry of the Attorney General have brought up to you or your office what to do in the event of a prosecution, which would be under the ministry or would be referred to the PPSC.
You're going to have to talk to the RCMP about what their plans are.
But again, this does not have to do with the RCMP investigation. This has to do with a decision that would be made in your ministry, and as I understand it, would be something that would be brought to you, if not already, eventually.
So as there are many ifs in that, I don't answer hypotheticals. What we're here today, what we're talking about today is the federal government's incursion into provincial space, as clearly laid out by the Supreme Court. And the federal government is not respecting that boundary, and it's holding up our projects.
Sure, but this is another important matter. So has what to do in the event of a prosecution being brought up to you by officials in the Ministry of the Attorney General in the Greenbelt matter? This is something that happened under previous governments. They referred it to the PPSC. So what is happening right now? Has it been raised or not?
You're asking hypotheticals. I'm not answering hypotheticals.
I'm asking if something has happened or not.
You're asking me if I would do something if something happened.
I'm asking you if officials in your ministry have come to you with the idea of what to do with the prosecution in the event that there is one in the Greenbelt matter, which would be a decision that you would be in charge of making. So has that been brought up yet?
And you're asking the same question. I'm giving you the same answer. I'm not answering hypotheticals of what might happen if something happens.
So has it been? Officials have not come to you with this.
That's
question.
all I'm going to say about it.
Has your office come up with a new process yet for awarding King's Counsel designations?
We are working on that, and it's something that we had been working on when we first launched them for the coronation.
Do you have a timeline on that?
I hope to be soon.
Are you going to retain your designation?
All of the individuals that received it through service to the Crown will retain their designation, and we'll announce the process shortly.
Minister, so the ruling talked about the feds and the provinces, and quoting here, exercising their respective powers harmoniously in the spirit of cooperative federalism. It doesn't really seem like a lawsuit would be cooperative federalism, so why not work with the feds on a solution to this going forward?
So you have to understand that we have critical projects. We have the 413 highway projects. We have projects that are going to be held up, that are being held up, because of the confusion caused by the federal government. There should be no confusion. The Supreme Court of Canada said that their act was largely unconstitutional, with the exception of 10 sections, 81 to 91. Everything else is unconstitutional. So for them to say it's just a friendly suggestion and that they'll potentially work and they'll potentially do that, the court was clear in a 5-2 decision. So we can't wait for them to Minister Guilbeault to have that conversation. We need to get certainty so we can move the projects forward.
Presumably a court challenge would take a bit of time. Like, the two governments could just get together quickly and kind of resolve their differences around this. Like, the feds have gotten the marching orders from the Supreme Court.
We are filing with the court as we speak, and we can certainly still have the conversation, but we're not going to wait and have our projects held up. We have 500,000 people coming into this province every year. We need the infrastructure. We need the highways. We need all of the pieces to come into place. We're already behind. And just think about that. In 6 years, that's City of Toronto repeating itself. We cannot wait for Minister Guilbeault to decide that he might listen to the Supreme Court when they were very clear. So we're going to make it clear by coming to the federal court and ask them to expedite, and we can get on with our very important projects.
How many projects are being held up right now? There's a 413. What else?
There are several. We're going forward with two, the two imminent projects. We have the Parkland, we have Ontario Place, and we have the 413. We have imminent decisions being held up on both of those.
All right. And how long do you think it would take to get this judicial review through? Like, do they have to agree to do it and then they have to do it? So what's the typical timeline for something like that?
So when we ask for an expedited, the judicial scheduling, of course, is within their purview. So we don't have any guarantees on that. But we are filing today, and there will be a timeline for the federal government to respond, which is pretty short. And hopefully we have a hearing sooner than later. We have imminent deadlines on some of the projects.
So do you think this could be wrapped up in 6 months, or might it take a year? Or
It could be wrapped up in 6 months. There is, of course, an appeal to the Federal Court of Appeal and a potential appeal with leave to the Supreme Court. Or Minister Guilbeault could say, yeah, the Supreme Court is going to be given the deference that is due, and we won't be holding up these projects.
is there any chance that putting in this application might kind of spur the federal government to meet with you and come together on this?
We have a great relationship with the federal government. I mean, I had a wonderful relationship with Minister Lametti, and Minister Ferrani has been fantastic. We were at an FPT, actually, when the decision came out. So it's if people want to come to the table and have the conversation about how the federal government should be following the decision of the Supreme Court, phone's on.
Are you aware of other provinces doing the same type of review?
I'm not sure if they will or not. Our projects have really tight timelines to be able to go forward, and that's the urgency of them. That's why we're not going for a global, everything. But if we get the answer on these that are imminent, it'll answer the others too.
What's the 413 deadline that you're concerned about, the eminent piece of it?
Well, part of the challenge is with the Act the way that it is, there is no number of times that a proponent would have to keep resubmitting. And the federal government has flagged some potential issues. And so there is no end point, and we need to get going for all the reasons I talked about, the housing and the need for infrastructure and all the pieces. So we can't wait on that and be in a constant loop of who knows when.
On another subject, I know there's prosecution of some Hells Angels leaders that have fallen apart because of a lack of court funding. What guarantee can you offer that similar projects, prosecutions of organized crime leaders won't fall apart in the same way?
Yeah, so I can't speak to the specific, of course, but the amount of resources that we've put into the criminal backlog that we have and into the system are in the tens of millions of dollars, 72 million in one bucket to deal with that. Talking with the federal government about making sure that we have the judicial resources in place for some of the matters. And of course, we've been taking very aggressive moves in terms of staffing to make sure that we have the complement to move the system consistently forward.
Minister, just back to this. So, we have the court saying, exercise respective powers, cooperative federalism. Minister Wilkinson said to the provinces and territories who brought the lawsuit forward, Ontario being one, I would suggest that we collectively commit to this being the last time we look to settle our differences in court. You're saying you want to bring this legal action forward to get clarity and to speed up the process, but it's sounding like the process could take a bit of time, and the government is kind of offering an olive branch, the federal government is kind of offering an olive branch to get that clarity. So if those two things can kind of be, if those two considerations can be satisfied by just working with the feds on a solution, why not take that?
So let's be really clear what happened. The Alberta Court of Appeal was asked to answer a question. It went to the Supreme Court. The Supreme Court said in a 5-2 decision, we're not even talking a 4-3, in a 5-2 decision said the federal government is in the provincial space. And the challenge is they did it in a reference. So a reference isn't a traditional court decision, but it is guidance. And there have been some very important references in the history of Canada. The response from the federal government was, well, the law is still in effect. We may amend it, and we're happy to talk about it. But the court said it is unconstitutional.
Has there ever been a case where the federal government hasn't responded to a reference ruling quickly? Because like everything that I've read and understand about this is they are going to respond fairly quickly.
It's not whether they're going to respond, it's how they're going to respond. What we're hearing and what they're saying publicly is that they're going to respond by amending, by keeping it in force, by continuing to occupy that space. They're completely ignoring what the Supreme Court said. And we need to be clear. And we need to be clear not because we need to have a vigorous discussion with the federal government, because it's holding up infrastructure. And we need to get the highways built. We need to get the homes built. We need to have the pieces in place. And it's redundant legislation and it's unconstitutional legislation. It's in our space.
You're talking about critical infrastructure, but how is Ontario Place critical infrastructure?
Look, parkland is infrastructure, and it's all critical infrastructure. It's a world-class site. It's going to be a world-class site that will bring people. We have a choice. We can let the place deteriorate and become derelict, as it has in parts, or we can move forward with it. And we have an aggressive plan to move forward with it. It's one example of the kind of infrastructure that we need. It's the same as the highways. It's the same as the housing. It's the same as all the other pieces. And at the core of this is about who gets to decide what goes forward, who drives the process. The federal government says that they want to. Well, the Supreme Court said it's not your job. And so you don't need to be there, and you don't need to be slowing things down. Ontario has a very robust environmental assessment process, and we deal with our First Nations partners and others as we go through them.
So do you think that the Impact Assessment Act should just be like scrapped entirely?
Well, it's not my opinion. The Supreme Court said that, with the exception of Section 81 to 91.
But yeah, isn't there kind of like, they didn't fully say it, like the whole thing is unconstitutional. It's like the screening and the decision parts of the process are the bad ones, right? There's a project designation part is still fine. The information gathering part is still fine. They also said the fact that a project involves activities primarily regulated by the provincial legislature does not create an enclave of exclusivity. So
what they said was that it's redundant, that it's not necessary because it's provincial space, and that all of it except for 81 to 91 is unconstitutional. That's what they said. So we have projects that are being held up. The 413 is being held up. Highways being. I'm going to tell you, when I was a kid, I grew up at Highway 88, you know where the Husky is with the big flag? Okay, I grew up 2 miles west of there. When I was a kid, I used to ride my bike out to the Highway 400 to watch the traffic back up. Now I represent Barrie, part of Barrie. If you've gone north on a Thursday or a Friday, we are in a big, big crisis in terms of building infrastructure. And having the feds weigh in spaces that the Supreme Court says that they shouldn't be, that they don't have the right to be, and hold up projects is fundamentally wrong. So, and at worst, there's confusion. We need clarity. So that's why we're going forward. We're going to get clarity on this so that we can move forward with projects.
Last question. You don't think you can get clarity by working with the feds on a solution go forward? You think clarity could only be got through legal action?
Minister Guilbeault could say tomorrow, you're right, this doesn't apply, those two projects are no longer of interest to us.
Pretty good.
Thank you very much.